Now let's do some political questions, Attorney General. Because you are the government, there are two articles that I set out, Article 78 and Article 128. 78 is appointment of ministers like yourself, executive appointment by the President, ministers of state. There's no limit on it. And people have criticized President Akufo-Addo for appointing over 100 ministers. And they're saying that if we don't limit this, another president may come and appoint 150 ministers, 200 ministers. So that's one. The other one is 128, which is quite critical, the lack of upper limit of the Supreme Court. Particularly Akufo-Addo's government, which is sort of birthed out of the Ghana Bar Association, if you like, is being accused of packing the courts and appointing judges upon judges because there's no upper limit. Do you think, in the whole conversation now about constitutional amendment, that we should look at 78 to limit the number of ministers a president can have? Because some people think it should actually be 19, which is cabinet, as delineated by the Constitution. And then also to limit the number of judges that we may have. 128 makes a minimum of 10, the Chief Justice and 9 others. Should we say 13 final, 14 final, like America has 9 only, and they will have 9 all day long, all year long, 100 years long, they will have 9. We know that there are discussions in America now to amend them. Are you of the view that 78 and 128 should change?
Sure. So I think that these are quite interesting questions, and of course, always susceptible to all manner of emotional and political interpretations. Now, inherent in Article 78 itself is a limitation. The president is enjoined to appoint maximum 19 as part of his cabinet. But the president is, of course, at liberty to designate any agency, any part of affairs of state as a ministry and appoint a minister responsible for it. Now, I do not think that there ought to be a constraint in that regard. I think the real difficulty with Article 78 is the requirement on the president to appoint majority of his ministers from parliament. I think that that's a provision crying for constitutional amendment. I do not see it as justified, because that inherent in that is actually a situation where Parliament will be undermined effectively, because if the president is enjoined to appoint most of his ministers from majority of his ministers from Parliament, clearly most parliamentarians will be looking over their shoulders for appointment into the president's government, and that effectively has an effect on the independence and efficiency of Parliament and all. So I think it's a provision that has to be amended. Now, with regards to the Supreme Court, it's also pertinent to recognize that the Supreme Court of Ghana has a variety of jurisdictions. The Supreme Court of Ghana is an appellate court. It's a court of original jurisdiction which deals with constitutional matters. It's a court that you have recourse to if an allegation is made and a document that is required of a person to produce in proceedings before a court borders on national security and therefore does not have to produce. It has that jurisdiction under Article 135 of the Constitution. Has the jurisdiction in respect of presidential election petitions. It also has jurisdiction has a review jurisdiction, has a supervisory jurisdiction over lower court. So indeed, you see a combination of jurisdictions exercised by the Supreme Court of Ghana. And I think that the difficulty with, or the lack of efficiency with all respect, if at all, on the part of the Supreme Court, is not really in respect of the number of judges or the limit to the judges, but it's actually with respect to how these jurisdictions are exercised. Now, I'm of the view that in view of this multiplicity of jurisdictions exercised by the Supreme Court, it will be we'll be shooting ourselves in the foot as a nation if we go by the practice in the United States of America, where we appoint only 9 judges of the Supreme
11
Court,
or 13.
So I think that there ought to be some flexibility. And over the years, recently, there has been the development of some a convention whereby the Supreme Court is always 15 plus the Chief Justice, or maybe just 15.
How many do we have now?
So now we have 14 in all.
Including the Chief Justice?
Including the Chief Justice, with the recent appointment of
so now that's not the highest number we have had. We've had 15 before. We've
had 15, we had 16. We at the point in time, because of the imminent departure of certain judges from the court,
we had a bit more.
We had about 70, but not just for a few months when the Supreme Court judges were.
But the point you are making is that they have a lot of work to do.
They have a lot of work to do, and I think that I have always been discussing this with the Chief Justice. I've also been raising it at the Judicial Council and all, that I think there must be a rethinking of the practice of the Supreme Court. I think we should rather go by, in terms of the practice of the Supreme Court, we should adopt the American example, where the Supreme Court does not entertain any case at all. The American Supreme Court, even though...
No original jurisdiction?
No, I'm saying it does not entertain just any
case at all. Okay.
So the American Supreme Court, yes, is the court for constitutional...
So that cases don't travel automatically to the Supreme Court?
Yes, so you may have a right of appeal to the Supreme Court, but the Supreme Court can exercise its power.
Whether they will hear you or not?
Or hear you or not. Because
in a preliminary hearing?
No, there can even be a practice whereby some judges, maybe 3 judges of the Supreme Court, make that determination. And indeed,
develop a roster for the court.
I've seen it in the Scandinavian court. We did this recent case in Norway, and that's a practice that I was quite impressed with, the Norwegian example. So an appeal is not heard as of right in the Norwegian court. You have a right of appeal, but the right of a hearing.
I see. That's interesting.
Yes, it's not. So there's a plenary determination by
so
a court
if they determine that they won't hear it, what happens?
That's it.
They return it to the Court of Appeal?
It ends the matter. And they determine whether they will hear it only when there's a new or important matter of law to be raised, not an important matter of fact. So the Norway Supreme Court does not determine appeals based on matters of fact. Does not entertain questions about the evidence. So you cannot see, as we say in Ghana, the court, that omnibus appeal basis, the judgment was against the weight of evidence. You can't do that in
when it doesn't mean much.
Yes,
it means everything.
It means everything.
Doesn't mean much.
The judgment is against the weight of evidence. It means you have to scrutinize the evidence and see whether indeed the judge was right in giving a verdict for or against you. I mean, it doesn't happen at all. It must be on account of a new and important matter of law. So
your point is that we may need sufficient Supreme Court judges. Okay,
yes,
about that.
So I think that, yes, if the Supreme Court is combined appeal, the Constitution, when it gives the right of appeal to a person from the Court of Appeal, does not set out the procedure for regulation of that right. That procedure for regulation of that right is reserved for the Rules of Court Committee under Article 157 of the Constitution. Article 157 enjoins the Judicial Council to set up a Rules of Court Committee. As the Rules of Court Committee is set up, and it develops the rules of practice for any court at all. So the rules of practice enacted for the Supreme Court must require that in terms of appeals, there must be a satisfaction of this basis before the appeal be heard. That does not, in and of itself, curtail a person's right of appeal. It's only a regulation of the right. Because indeed, even now, the reason or the basis for an appeal to be ruled in your favor is evolved by the court itself. The court has set its principles. So in respect of this general ground, judgments against weight of evidence, the various cases over the years have spelled out what it means. So I think that there should be no impediment.
So on that, you think that we should hasten slowly to limit the numbers at the Supreme Court, because there's quite a bit of them. So then we have to reform the way they do their work.
Precisely. Rather, we should concern ourselves.
We are expecting a new Chief Justice this year. Is that correct?
Yes.
So when is it going to happen?
Well, the Chief Justice, with all respect, is at the end of May, 28th of May. So there must be a replacement. So
there will be a new Chief Justice before the 28th of May or after?
It has to be after. You cannot appoint before the 28th.
Okay, maybe an announcement made, and then swearing in done later on. So this will require parliamentary approval, isn't it? So nomination by the President and parliamentary approval.
By the President, a Council of State advising on it, the Judicial Council first, and looking at it, Council of State advising on it, before the President submits it to Parliament. So it has the participation of all these important issues of government or state, the Judicial Council, Council of State, and then ultimately Parliament of Ghana will consider the person.
Okay, so we'll wait and hear that.
Must be a person.
Maybe by our next interview you can tell us who it will be.
We'll see.
Hopefully.
I think all of them.
Let's get back to Parliament.
All of them are fit and qualified.
All those there now?
Yes.
Okay.
Plus those outside.
I see. Plus all the senior members of the bar
because you must
who have done 20 years. 15.
Qualified to be on the Supreme Court.
15 years at the bar. So all those who have done 15 years at the bar should start praying.
Well.
Okay.